states 3 financial promises: that he won't take a salary, that he won't charge anybody for land leases, and that he won't have any cost for mediation centers that he plans to build. All these are political promises for his running for governor. So for somebody who's broke and cannot afford to pay his family obligation, I don't understand why he would forego taking a salary. He has run many ads on television, on major TV channels for his company, Mortgage Specialists, and those cost, I'm sure, significant monies. He spends his money recklessly in pursuit of the stateofcorruption.org website. He's posted billboards on Route 93 in Medford, Massachusetts. He's paid to Clear Channel. It says paid by Mike Gill right on them. Running for governor of New Hampshire. Posts these in Massachusetts on Route 93. I'm sure at a very big expense. I have pictures of all that as well. So the stateofcorruption.org website is a very sophisticated website. As I said, it generates no income, but it does reach a significant population. It includes videos, multiple videos, and multiple radio broadcasts. It also has had visits, this is as of yesterday, of over 4.5 million to this website. So what he puts out there is reaching a vast audience, and it's very sophisticated, so it's a lot of money that he's spending on this. And I have this for you as well. Okay, Your Honor, I have his intent to stop the court law ordered alimony payments. I have copy of a text message that he sent that says there will be no more alimony payments.
Objection, Your Honor.
What's it? That he sent to me.
Well, that she sent me, I wanted her to send you all the text messages that I sent her, all regarding these issues, just not one. It was a series of phone calls.
You can present your evidence, sir, when it's your turn.
This is
Objection is overruled.
Thank you, Your Honor. And this is for Mr. Gill. Thank you.
And ma'am, what is this again?
It's evidence that he had no intention to pay me alimony as of after July, and you can see his text in writing saying that I will no longer receive alimony, and that is proven to be true.
Okay.
My next
Your Honor, you see,
evidence is an
object.
example of
Overruled.
Thank you, Your Honor. Example of his irresponsible behavior, putting our family's financial future at risk. I have a text message here that he sent to me that says there's nothing I wouldn't do for my children, nothing. Do you understand what is happening the way I told you was going to happen? They're going to take everything. You can see it right here. And the last statement is key here. It says, because you're afraid, well, I'm not. And if I go down, these bastards, excuse me, all know they were in a fight.
I'd like that, have that submitted as evidence.
I have a copy for you right here.
Good.
Okay, in addition.
Have that.
Okay, so this is for the judge.
Yes, it is.
And I have one for Mr. Gill as well. And behind it is for Mr. Gill. The last page on that attachment, as you can see, is straight off of his website. It was an interview he conducted with a woman. He's exposing, his mission is to expose corruption on every level on the planet, I think. So the interviewer, as you can see on the last page, it's highlighted in orange, she asks him, have your mortgage specialist business been impacted by the actions that you've taken? And then his response in the bottom, in yellow, it has hurt the company, and I spend my money on fighting, but I made that commitment. Listen, I'm prepared to lose everything. Your Honor, this speaks volumes, this statement.
Here you wanted to submit it as evidence. This is important information she's giving. Life-threatening information.
Ms. Gill decides what she submits. You decide what you submit. I decide whether it's accepted or not.
But it will be on a transcript, is that right?
Denied.
point, Your Honor, is on page 44, he states the cost of our divorce. Yes, this divorce cost an absolute fortune. We both are in agreement that it cost $5 million. I can also say that anybody reading that would know that it would come from a marital estate that was significant enough to pay for a $5 million divorce. So that's further evidence of what our marital estate was. And then the other portion is not applicable. Okay, so that's that piece. Okay, we're getting there. And then I have a copy of the final. It's again from our final divorce order, and this is
about 5 minutes.
Yep. I don't even think I need all that. This is where we agree. We sign a mutual release within our divorce that we will not bring lawsuit against each other. And Mr. Gill has filed a lawsuit against me in the Supreme Court. As you know, he's filed a lawsuit against me in the Superior Court, his latest action against me. And, you know, we're here all the time.
You mean the appeal in the Supreme Court, ma'am?
Yes.
Right, that's just an appeal of this board, so I don't think that applies. But the issue, if he's violated other provisions of the divorce decree, again, that's not before me today. The issue today is alimony.
Okay.
Okay?
All right, thank you. And just oh, yes, Your Honor.
I'm going to return this to you, ma'am. It really is not.
Okay, that's fine. Thank you.
To the
Your Honor,
issue
thank you.
today.
And the other comment that I offer is that I watched some of his videos, just a tiny fraction, in order to prepare for today. And within the body of one of his videos, actually in two, he stated, and there's probably more, that he has a standing offer out of $10 million for any lawyer that will represent him. He's had it standing for 2 years and has yet to have an attorney accept the offer. I don't understand how he can afford to make a $10 million offer when he can't even afford to take care of his family, according to his words. And that's it, Your Honor.
Okay.
Thank you very much.
Thank you. Hold on 1 second. Okay, we were scheduled for 1 hour. We used about 10 or 15 minutes of that, just getting the groundwork set for today's hearing. Ms. Gill used almost all of her 30 minutes. You have 30 minutes, so you may proceed.
We ready? As far as the divorce decree, we've got a copy of the divorce decree. The divorce decree says that it can be, my alimony and child support can be reduced if my income is less. Well, my income is 0. And I'm going to show you the numbers. So that's what it says. It's not a promise. We spent $5 million because they were trying to get through statutes of limitations, John Ross and Tober. Right? That's why we spent $5 million. We don't have them now, do we? And that estate was sizable until they stole it all, and they took advantage of Mrs. Gill's mental illness.
Your Honor, I object. I have no mental illness, and once again, he's referring to.
Okay. Mr. Gill, I'm going to caution you that has to be deleted from the video recording.
Deleted from the video. But the court does have the records, and they were destroyed on 2 different occasions. Okay, I go on. Now, so on the divorce decree, it says that exactly. And it also goes on to say that I picked up all the tax liens. First of all, I gave them 3 offers to settle that were much better than what Ms. Gill took. Again, statutes of limitations.
I don't want to go into settlement discussions
Right.
before the decree. That's not the issue.
So the divorce decree says that I can reduce it. Now, she talks about taking care of my family. I was paying $10,000 a month. When she refers to my son being 18, I was paying for my child support on my daughter who was 21 and 20 during that time. Now that my kids are all grown up, my support payment isn't $7,500. Now that I make zero, guess what? My payment doubles. Now, in the paperwork for that alimony was done criminally by someone discussing this with the Justice Department right now for immunity. That would show that this was corrupt. Now, so one, by this divorce decree, I'm allowed to have it decreased. The fact that I'm making no money, now I'm going to spend the profit and loss of this company. You can say that we're at a loss.
You have a copy for
Yes, she has a copy, you have a copy, Ron. So I testify that these numbers are completely accurate.
Hold on one second, sir. Can you tell me what this is?
That is the financial for the company. You can see that we're losing $250,000 so far this year.
Is it done internally on a accounting software, or is it done by an outside accountant? Who prepared it?
It's by a controller of the company that I certify 100% is accurate to the penny. And it's the same information that will be forwarded to the IRS. So that's numbers and proof. And regarding state of corruption, that has been the business that's been generating. People have been coming to us because we are fighting this fight. So it has held business.
I'm sorry, I lost you. Say that again, sir.
Well, I said, by the advertisement that we spent on state of corruption, that is what's keeping the business open. That is the basis of our customers who are helping us to fight. Now, so let's get this straight. I paid child support until all my children were of adult age. This court increased my payments now that my kid's older and we make zero. Okay? Now, if you remember, Your Honor, we came to this court for a hearing. And we turned around and I said, Miss Gill, put a big sign up in front of the business that said for sale. And I'd like to give you a copy of that. You want to know what happened to the business? That's what happened to the business. And I asked this court a year ago to prevent that, and you didn't. I got the business. Now, you know what she did immediately after? What her attorneys told her? They filed liens against on my properties. You know why? Just like I said this before, Your Honor. In the last hearing we had, I said that the DRA and your buddy next door, Anderson, was going to see the DRA. They gave me a summary judgment. So that means we have a judgment against us for millions. So I'm in the negative, not Sarah, because Sarah put on my remaining assets a lien for $2 million. I want on record that you seized the judgments. Now I'm going to give you the judgments, Your Honor. This is the State Department judgment. Richard Henry, Assistant Attorney General, wrote it up. He's off to California, you know. So I'd like to submit my new financial. I've already given Sarah a copy. And I'd like to submit the lien from Mr. Ross. Again, corrupt. And actually the DRA too. But that's how it works. Which is why I have my life friend, Your Honor. I'd be more than happy to send you those texts that we talked about earlier. So.
I'm sorry, the last one is what, sir?
That is the lien from Ross on my personal home. So I'm being leveraged by the IRS, the DRA, the Banking Commission, Family Court, which, by the way, I just spoke to the other gentleman running for governor, Ed Blunt, who sits on the committee of Family Court, and I'm speaking to them in January. So we're going to have to explain to them why I'm paying this much money or I'm losing money and the conditions of these cases, which he seemed to be already aware of. I guess Mr. Foley's under investigation. You know, the first judge on the case. When I turn around and say that putting money into the state of corruption is doing the right thing, I'm getting thousands and thousands of people coming forward saying the injustice of these courtrooms. I'm getting told I've had to sit down with Mr. Trump regarding these matters in this state.
Okay.
Did you speak to the guardian ad litem concerning his reports about my children? Yes or no, please?
I don't recall without going through.
You don't recall.
I don't recall.
You're my attorney.
Yes?
I spent about over 400,000 with them. You don't recall that you talked to guardian ad litem?
I don't.
Did you speak to Dollar about what the guardian ad litem said?
When he said what?
Did you speak to Donald Sedgwick, your underling, about what was concerned with the guardians and what they read?
About what? When?
I'm asking you.
I don't understand your question as a point in time. I've told you I don't have an independent memory presently of speaking with the guardian.
So you have no memory of speaking to the guardian ad litem. Yet, in the beginning of divorce, if, say, for instance, I had a child who had 3 attempts on his life, and that was in that guardian report, wouldn't you consider that important, especially when we're in there from the beginning dealing with therapist records? It was also what the children were saying. Why wouldn't you know that? That could have brought the divorce to an abrupt end.
The problem, sir, is we're mixing now theories versus, we're trying to focus in on what you were charged for. So you asked a legitimate question. You said on August 22nd, where he was charging you with something to do with the guy.
Then I would ask you this. Is it quite common for a divorce attorney, when there's children involved, to speak to the guardian ad litem?
Yes?
But you don't know if you did.
I don't know if I did. I know that Ms. Sedgwick had that
But
responsibility.
yeah, you are. The beginning of this divorce,
Go ahead. You know that Ms. Edwards, go ahead.
I know that Ms. Sedgwick had contact with Mr. Cunningham and had a lot to do with the work that was done in connection with the parenting issues. It's reflected that she did that.
parenting issues, wait a minute. So the therapist records, we now know, were all destroyed.
We don't know that.
Well, we don't know where they are. You don't have them, and I spent a lot of money to get them. Is that true?
I don't know where they are. And
But did I spend a lot of money to get them, and do I not have them? He's answering a question to the question I'm not asking him.
What's a lot of money, sir?
Oh, I don't know. Between what I had to pay for my wife and myself, I don't know, $1 million, a lot of money? Let's see what happened. We didn't get the therapist records, did we? We didn't get Tober removed, did we? So what did we accomplish?
May a witness now give an uninterrupted answer to your
Sure. You want to go ahead.
So,
Okay.
Ed,
we did not get the therapist records. The last order that was entered was to depose Dr. Broussard and have him produce records to the court. You terminated our representation before that could be done. My understanding is that you never got them from any subsequent counsel.
okay, well,
And the
Then I
motion
ask
to
this.
disqualify was not filed. Let me just finish answering your other questions. The motion to disqualify Mr. Tober was not filed because I made my professional judgment that I would not do so and offered you the opportunity to have another lawyer do it for you.
and we keep going back to the same. So, there was no mention of getting Dr. Broussard deposing. In fact, he said he had his records destroyed. What were you going to get from the records? How about this? You said you don't remember the Guardian ad litem reports. But if we lost, we couldn't have the records. But if they lost, we didn't get them. It could have been one of the multiples. Wouldn't you have then asked the Guardian ad litem? Because I'm making suggestions that my son is threatened. In fact is, later in the divorce, we find out from a court-ordered therapist that came in here that they insisted on. Guess what? Clay was just depressed. But the order was, he should never see his mother again.
Okay.
Now, do you think it would have been important to know about the guardian report? Why wouldn't you ask and know about the guardian report if you knew my concerns with the mental illness of my wife from the beginning of the divorce?
I still don't know what question you're asking me. Could you ask me one at a time?
The guardian ad litem report.
Yes.
Once the therapist records were missing, they claimed destroyed. You claimed it, maybe not. But we didn't have them. Wouldn't it have been quite natural to speak to the guardian about the welfare of my children and what they were saying?
I can't answer the question as phrased.
We need to have questions.
I'm asking a question, was there a concern? Would you not say that the welfare of the children is paramount in a divorce case, Mr. Ross?
Welfare of children is a paramount issue for parents and in a divorce case, yes.
Thank you. So why wouldn't you speak to the guardian, particularly when the concern from the beginning of them coming in was the health and welfare of my children?
I learned that Steve Tober would be adverse counsel. I knew Tober as he represented Wiggin and Norrie and had even represented me personally on a sensitive matter. I also knew that Tober was very close to Ross, that the two were good friends, and that Tober had previously represented Ross. From the time Tober first appeared in the case, his litigation tactics were extremely aggressive. Tober took a scorched earth approach. Tober's approach would be to excessively bill the divorce case, all of which would unnecessarily lead to increased legal fees for Gil and depletion of the marital estate. Eventually, it would become clear to me that the goal of Ross and Tober collectively was to extract considerable legal fees out of a once sizable marital estate. In December 2007, Gil became uneasy with Ross as his attorney. I recall numerous telephone calls and in-person conversations with Gil, where he informed me that he was not comfortable with Ross as his attorney. I told Ross early on that there was a conflict of interest given the aforementioned legal representations and relationships. I then directed an associate, Megan Beauregard, to perform legal research on the ethical issues involving conflicts of interest. Following our research, I concluded that a material conflict of interest existed and that we needed to disclose the same to the client. At the time, I did not know, but would soon learn from my associate conducting the legal research, that Ross, too, had been represented by Tober in cases involving ethical and legal malpractice violations. Given the above, I prepared a motion to disqualify Tober as attorney for Mr. Gil's wife in the divorce. The basis of the motion was the aforementioned conflicts of interest, the overall impropriety, and the potential significant compromise of the client's interests in a hotly contested divorce. I had countless discussions with Ross regarding the issues of the conflicts and argued strenuously that we move forward on the motion. On several occasions, I asked Ross why he would not permit me to simply talk to the client about the conflicts issues, especially since I had come to learn that Ross, too, had been represented by Tober. I could not understand why Ross was so insistent in his refusal to seek to disqualify Tober. I became so frustrated and distraught over these issues that I began to confide in several people close to me about the ethical dilemma. Specifically, I talked to Megan Beauregard, as well as my then current husband and even a relative, all with the single goal of trying to find out why a senior partner at my firm would block the disclosure of a conflict of interest. Up until this point in time, I had only the highest regard for Ross. I worked extremely hard on his cases and felt fortunate to work with him. Gil was unaware of the conflicts of interest relating to Tober's prior representation of me, Ross, and Wiggin and Norrie. However, from the inception of Tober's involvement, Gil was uneasy with having Tober involved in the divorce because just prior to Tober's appearance, the records of a therapist, Dr. Broussard, went mysteriously missing while Gil's wife was represented by attorneys Rona Wise and Matthew Kozel. As I mentioned, in December of 2007, Gil became uneasy with Ross as his attorney. Gil expressed concern that a plan existed between Ross and Tober to bill the divorce case excessively. Gil was concerned that Ross did not want to have any contact with him. On numerous occasions, I continued to inform Ross that Gil was uneasy with Tober's involvement and was likewise uneasy with Ross's representation of him. I implored Ross to speak with Gil regarding Gil's concerns. However, Ross did not want to deal with the issue of whether a conflict existed by virtue of Tober's involvement, and Ross would not speak with Gill. In Ross's opinion, no conflicts of interest existed by virtue of Tober's involvement. Ross never discussed with me the subject of Tober's prior representation of him. Again, I could not understand why Ross seemed to be fighting not to move to disqualify Tober. During this time period, the global economic crisis had begun, and there were numerous in-firm discussions about rainmaking and billing clients. It became clear to me that I was being set up for something, and that if anything went wrong with the divorce, I would be blamed. Indeed, I knew that eventually the aforementioned conflicts of interest would lead to real problems with the client. I informed Tober of the motion, and it was clear that he was troubled by it. For example, at a court hearing following having advised Tober of the motion, Tober appeared to be trying to intimidate me by standing uncomfortably close to me, scowling and generally looking threatening. I also began to realize that Ross's behavior in litigation style became unusual. For example, Ross informed me that if and when Sarah Gill's deposition would go forward, he would aggressively explore incidents of sexual abuse she suffered in her past. Doing so, however, would not advance the interest of Gill nor be relevant to any issues in the case. It was also out of Ross's character to engage in such lines of inquiry. It then became obvious to me that this line of inquiry would only be used to delay the litigation by forcing Tober to stop the deposition. Indeed, Ross was so committed to preventing the deposition of Sarah Gill in order to allow the extremely lucrative, approximately $100,000 per month case to continue, that he told me that Sarah Gill would never sit for a deposition. Ross said that either Ross or Tober would feign a heart attack or some other medical problem in order to stop the deposition. Ross told me multiple times that Sarah Gill's deposition was simply not going to happen. Meanwhile, it seemed as though every effort I made to advance the case was being thwarted. For example, I tried for many months to secure the deposition of the opposing party, Sarah Gill. Yet, when I would discuss this with Ross, he seemed unconcerned that we were unable to secure the deposition. Likewise, as discussed below, Ross was unconcerned and uninterested in the mysterious unavailability of Dr. Broussard's records. While Ross and I had worked closely together for years, there was now obviously sharp tension between us, and he was beginning to communicate less with me. I began to believe that Tober and Ross were in constant communication and were conspiring to frustrate the case from being advanced to closure. During this time frame, Wiggin and Norrie's financial challenges became more acute. For example, there were no bonuses distributed at the end of 2008, and the litigation activity in the firm had declined precipitously. The firm had many meetings regarding its financial challenges and the economic slowdown generally in the legal profession during this economic recession. As the case continued, it became clear to me that anything concerning the case which I would tell Ross would soon be learned by Tober. I concluded that Ross was not representing the best interest of the client, but instead was acting in collaboration with Tober to continue the case and continue the sizable monthly legal fees being paid by Gill. Despite all the fees and my best efforts, depositions had been blocked or thwarted, and other depositions, such as Sarah Gill's, as noted above, surely would not take place under Ross's watch. I no longer trusted Ross. I stayed out of the office as much as possible. Occasionally, Ross would call me and inquire about the case. His most common question was to inquire about the client's current thinking. Through my conduct in the case, I began to make it clear to Ross that I would not be a party to what I saw as unethical conduct, and this created greater distance between me and Ross. Eventually, this friction was expressed in an email response that I had sent to Ross. He had asked me, in an email, to engage in some ethically questionable conduct, and I responded that I would not do it. By this point, I was close to leaving the firm. I did express to Ross the client's displeasure with the case, the lack of depositions, and other related issues. I informed Ross that the client wanted to interview other law firms. I soon interviewed William Levine of Lee & Levine in Boston, Massachusetts, as potential successor counsel to Wiggin and Norrie. I explained to Levine that depositions had not been conducted, that discovery efforts were being thwarted by Tober without resistance from Ross, and that we had not obtained the therapy records of Sarah Gill. I said that I needed to find successor counsel who could properly represent Gill's interests. I also informed Levine about Ross's conflict given Tober's involvement and Ross's apparent efforts to force the expensive case to continue by delaying necessary proceedings among other things. They listened to what I had to say and agreed to a second meeting. After listening intently to the challenges I was facing in representing Gil, Levine advised me that the situation would not likely end well with Wiggin and Norrie. He then gave me the name of another lawyer with an expertise in ethics. That lawyer, who also listened intently as to what I had to say, advised me to leave the law firm of Wiggin and Norrie. As for the therapy records of Sarah Gill, they had been in custody of her therapist, Dr. Broussard. At various times, Dr. Broussard's office had represented that the records didn't exist due to 1, a water and flood problem, 2, a fire, and 3, an accidental shredding by Dr. Broussard's secretary. Broussard's office even stated that the records might be in storage. Ross rejected my efforts to challenge in court these suspect and inconsistent grounds for allegedly not having medical records. I came to the conclusion that Dr. Broussard's records may not, in fact, have been destroyed, given my review of the records of Dr. Garber, which note that he reviewed Dr. Broussard's records in which detail a conversation Dr. Garber had with Dr. Broussard, wherein Dr. Broussard acknowledges the existence of the records. From time to time I had heard Ross make highly derogatory comments about Gil. This was unusual, as he typically did not make such comments about his own clients. Later in the case, as I began to understand what was happening between Ross and Tober, I reflected upon the fact that Ross strongly encouraged me to communicate with Tober by telephone rather than in writing, even insisting that I do so even though every phone conversation I had with Tober would subsequently be misrepresented by Tober, leading to follow-up letters, disputes, delay, and more legal fees. For this reason, I had long preferred to communicate with Tober in writing so as to eliminate such unnecessary work and delay. Ross never explained to me his rationale for why I should only communicate with Tober via telephone and not in writing. At some point toward the very end of my relationship with Wiggin and Norrie, I told Ross that I know what's going on here. I recall making a statement along the lines of, "How much money do you need?" I gave my notice to Wiggin and Norrie, advising them that I would be leaving the firm.